Hello everyone, I hope you're all comfortably busy. I and my colleagues are, although perhaps we're not getting quite as much of the can we exchange before Christmas madness as usual. Recessionary signals, I wonder. I'm going to rattle through 4 recent cases today in an extremely bite-sized manner. Case 1 reminds me of a teacher we had at school. Brillo was his nickname, as in the pad, something to do perhaps with the texture of his hair, who had a particular bugbear about boys clicking pens in lessons. A microcosm that of the recent case of Tajani and Fitzroy Place, where an intermittent clicking noise caused by thermal movement of the components of a facade was not held to be a nuisance caused by the landlord's developer for a flat tenant or a breach of quiet enjoyment, because nuisance has to be more than just a trifling disturbance, which the intermittent clicking of the facade was, as it would not be such as to awaken the average person when sleeping in the plaintiff's apartment. Case 2, Tan and Bundia. Who owned and thus who was responsible for the repair of a concrete slab which formed the roof of an extension to a ground floor property and a balcony for the first floor property above? Who was responsible when the leases were silent as to responsibility? Was repair the responsibility of the ground floor tenant or of the first floor tenant, or the landlord as a service charge item? The upper tribunal held that there was no inference in the leases that it was a common service charge item, and said that the most usual arrangement was that the demise of the lower flat would include the concrete slab between the lower flat and the upper flat. Therefore, the ground floor flat, and this scenario would also apply to offices in a commercial block, no doubt, had the full repairing responsibility for the slab, although the ground floor tenant was able to claim a proportion of the costs because of a tenant obligation in the first floor lease to contribute a reasonable proportion towards shared structures. Case 3, quite a horrible decision. The case is O.G. Thomas, something unpronounceable except to Welsh speakers, against Turner. A landlord served a notice to quit an agricultural tenancy on an individual whom he believed to be the tenant, unaware that that individual had assigned his tenancy to his company, no notice of that assignment having been given to the landlord. The Court of Appeal nevertheless held that the notice to quit failed the common law condition that it be given to the tenant, as it was not given to the current tenant. Thus, the notice to quit was invalid. Now, this scenario could play out unfavourably with break notices in a commercial lease, particularly for a tenant breaking a lease without having received a rent authority letter to be aware of the sale of the landlord's reversion. There is thinking that the tenant may be saved in this section by section 23 of the Landlord and Tenant Act 1927, although that would probably not exonerate a tenant whose systems had failed to process a recently received rent authority letter. Tenants looking to break should be ultra careful about correctly establishing the identity of the current landlord. Do involve solicitors when breaking a lease. As landlord or tenant, it's absolutely critical to serve the break notice on the right person, which exercise might involve serving the notice on more than one person to cover all bases. Case 4 is an example of the merits of applying to the Land Tribunal as a means of modifying restrictive covenants, preventing developmental use, as opposed to the more commonly used methods of getting title indemnity insurance or deeds of release, or a combination of the two. In Re Johnson and another, a couple owned a residential home subject to covenants from 1937 and 1965, preventing any trade or business whatsoever, and requiring the property to be used for the purpose of a private dwelling house only. The couple wanted to operate an Ofsted registered childminding business from their home, and they were able to make a successful application to the tribunal under Section 84 of the Law of Property Act 1925. And they were successful because those covenants didn't secure any substantial practicable benefits to anybody, and money would be an adequate compensation for any loss or damage suffered by the modification. In this case, no application for planning consent was required for their business, a business catering for up to 6 children, and therefore the tribunal decided that the covenants impeded a reasonable use of the property, and it exercised its discretion to modify the covenants to allow the childminding business to operate. One of the main advantages of bringing a case to the tribunal is that any order made by it is binding on all persons. Contrast that with a deed of release, which only provides a limited assurance that those who have signed up to the deed of release have released their rights. A negotiated deed of release and or insurance is still the preferred method, however, in our fast-moving world when time, whether justifiably or not, seems to be everything. There are indeed never enough hours in the day, are there? However, not long now until it is time to take a breather, if we can, over the festive season. And I'll see you all again on the 22nd of December for my Christmas property slice. Bye for now.